Good day and Assalamualaikum. This is Siti Hafsa M. Kumal. Together with my partner Alamina Vulpano, we're going to discuss assignment of credits and other incorporeal rights under the Chapter 8. So to start off, let us first discuss about Article 1624, which is an assignment of creditors and other incorporeal rights should be perfected in accordance with the provision of Article 1475. So in other words, the assignment of creditors and other incorporeal rights will only be perfected in line with the provision of Article 1475. So in order to better understand the Article 1624, let us first discuss or define what is an assignment of credit. So an assignment of credit is a contract by which one person, it could be the assigner or the creditor, are transferred to one another his right in action against the third person. So it is just an assignment by which one person transfer his or her rights and actions to a third person, which could be the debtor. And then, when it comes to the nature of the assignment of credits, the assignment of credits and other incorporeal rights is consensual, bilateral, onerous, and cumulative of aleatory contract. And in addition, it is really a sale. Thus, the subject matter is the credit or rights assigned. The consideration is the price paid for the credit or right. And the consent is the agreement of the parties, which is the assigner or creditor and the debtor, and to the assignment of the credit or right at the agreed price. And then furthermore, there is, however, one important difference, or there is at least, one important difference. After the transfer, a definite third person is obliged. In sale, the subject obliged is the whole world, which must respect the title of the buyer. So in order to achieve perfection of contract for assignment of credit, the contract for the assignment or transfer of credit and other incorporeal rights is perfected from moment the parties agreed upon the credit or rights assigned and upon the price, even if neither has been delivered. So in other words, the perfection can be achieved after the parties agree upon the credits or rights or right assigned and upon the price, even if neither has been delivered. However, the assignee will acquire ownership only upon the delivery. And now let us now proceed with the Article 1625, or an assignment of a credit, right, or action shall produce no effect as against third person. So wala daw action o walang effect sa third person ang assignment of credit unless it appears in the public instrument or the instrument is recorded in the registry of property in case assignment involves real property, unless it appears in a public document or the instrument is recorded in the registry of property in case the assignment involves real property. So as between the parties, the assignment is valid although it appears only in a private document. So if it only appears in the private document, the law does not require a specific form for its validity. However, it will only affect the third person if it must appear in the public document, or the instrument or document is attested and certified by an authorized public officer like the notary public, and in case it also involves real property, which is registered in the registry of property. And it is indispensable that it be recorded in the registry of property. Also, the assignee merely steps into the shoes of the assigner, the former acquiring the credit subject to defenses available to the debtor against the assigner. And then let us now proceed to the Article 1626, which says that the debtor who, before having a knowledge of the assignment, uh, pays his creditor shall be released from the obligation. So if yung debtor daw is wala pa siyang idea about the assignment, pero nagbayad na siya sa creditor, then he shall be released from the obligation. So the consent of the debtor to an assignment is not required. So in an assignment of credit, the consent of the debtor is not essential in order that it may produce legal effects. Hence, the obligation to pay does not depend on the consent of the debtor. Otherwise, all creditors would not be able to assign their credits because of the possibility of the debtor's refusal to give consent. And then, what could be the possible effects of payment by the debtor after assignment of credit? So before notice, in an assignment of credit, the consent of the debtor is not essential. However, if it is after the notice or before notice, but debtor had knowledge of the assignment, payment by the debtor to the original creditor after the former had received notice of assignment, whether or not the debtor will not also be released, whether or not he consented is not valid against the assignee. Even without notice, the debtor will not also be released from his obligation should he pay the creditor after having had knowledge of the assignment of the obligation. He thereby acts in the bad faith, and he can be made to pay again by the assignee. So let us now proceed to the Article 1627, the assignment of credit, which says that the assignment of credit includes all the guarantee accessory rights such as guarantee mortgage, pledge, or preference. So the extent of the assignment of credit, so the assignment of credit includes not only the credit itself, but also all rights accessory thereto. This follows the premier rule that the accessory follows the principal, but the parties may stipulate that the accessory right shall not be included in the assignment. So yung kasali yung accessory, however, the accessory rights shall not be included in the assignment. So, for example, let us give an example. DOC 50,000 with G as guarantor. C assigns his credit to T with notice given to T. So in case D fails to pay T, if D do nakabayad si D kay T, which is the creditor or the yung na-assign with notice, and the latter may enforce the guarantee of G unless the credit was transferred with the express stipulation that G shall be released from his obligation. So yung mag-i-enforce is si guarantor unless the credit was transferred with the express stipulation that G shall be released from his obligation. So let us now proceed with the Article 1628, which says that the vendor in good faith shall be responsible for the existence and legality of the credit at the time of sale, unless it should have been sold as doubtful. So, ang vendor daw is magiging responsible. A vendor which acted in good faith will be responsible for the existence and legality of the credit at the time of sale, unless it should have been sold as doubtful, but not for the solvency of the debtor, unless it has been so expressly stipulated, or unless the insolvency was prior to the sale and of common knowledge. Even in these cases, he shall only be liable for the price received and for the expenses specified in number 1 of Article 1616. The vendor in bad faith, however, shall always be answerable for the payment of all expenses and for damages. So what could be the warranties of the assigner of the credit? So when the creditor assigns his credit, he warrants only the existence and the legality of the credit at the perfection of the contract. It is only the creditor or the vendor which is acting in good faith. He can only warrant the existence and legality of the credit at the perfection of the contract. There is no warranty, however, as to the solvency of the debtor unless it is expressly the insolvency was already existing and of public knowledge at the time of the assignment. So when it comes to the liabilities of the assigner for violation of the warranties of the above warranties or the warranties that I've discussed earlier, liability of the vendor or the assigner in good faith is limited only to the price received and to the expenses of contract and any other legitimate payment by reason of the assignment. So, the assigner, however, in bad faith, is liable not only for the payments of the price and all expenses, but also for damages. And then let us now proceed to the Article 1629, which says that in case the assigner in good faith should have made himself responsible for the solvency of the debtor and the contracting parties should not have agreed upon the duration of the liability, it shall last for 1 year only from the time of the assignment if the period had already expired. If the credit should be payable within a term or period which has not yet expired, the liability shall cease 1 year after maturity. So, in order to better understand Article 1629, let us discuss the duration of the assigner's liability where debtor solvency guaranteed. So, this provision or itong article na to does not apply if the assigner acted in bad faith. So, this only applies for those assigner that acted in good faith. So, in case the assigner has expressly warranted the solvency of the debtor, the duration of the assigner's liability shall be as follows. So first, if there is a stipulation, then for the term or period fixed. Yung term lang, yun na fix ang pasusunod if there is a stipulation. However, if there is no stipulation, it should be only for 1 year from the assignment of the credit when the period for payment of the credit has expired, or for 1 year also after its maturity when such period for payment has not yet expired. That would be all. Thank you.
So, good day, ma'am. I am Mapapano Alamina, the reporter for this topic. So now, I'm going to report the continuation of Chapter 8, Assignment of Credits and Other Incorporeal Rights from Article 1630 to Article 1635. So, according to Article 1630, one who sells an inheritance without enumerating the things of which it is composed shall only be answerable for his character as an heir. Sale of succession or hereditary rights. This article refers to the sale of succession right or the thing to an inheritance before partition. An inheritance may be sold either with specification of the properties to be alienated or without enumerating the things comprising it, that is to say, the hereditary rights only, according to Article 1630 to 1632. So, the seller of an inheritance warrants only the fact of his heirship, but he does not warrant the object which make up his inheritance. So, for future inheritance cannot be subject of the contract unless otherwise provided by law. So, hindi niya pwedeng ibenta if buhay pa ang nagmamay-ari ng asset, even if you are the future inheritance of the property. But the hereditary and the succession rights, pwede na siyang ibenta nung heir. Now, pag nabenta niya ang hereditary rights niya for 100,000 pesos, example, sa'yo, so in that case, now, pag nagkaroon na ng liquidation or what we call distribution na ng property, tapos you only receive 50 pesos. So, you cannot get the difference of 50 pesos on your 100,000 pesos because yung binenta niya sa'yo is yung hereditary rights, not the value of the thing that the assignee was able to receive. Yung right, yung right ang binenta mo, hindi yung value ng thing. So, he won't be liable for the difference of 50,000 pesos. Now we're going to Article 1631. So according to Article 1631, one who sells for a lump sum the whole of a certain rights, rents, or products shall comply by answering for the legitimacy of the whole in general. But he shall not be obliged to warrant each of the various parts of which it may be composed, except in the case of eviction from the whole or the part of a greater value. So for this article, sale of the whole of a certain rights, rents, or products. In the sale of the whole of a certain rights, rents, or product for a lump sum, the subject matter is the totality of such rights, rents, or products. As a sequence, the vendor warrants only the legitimacy of the whole and not the various part of which it may be composed. The vendor is not liable for eviction of each of the various part unless the eviction involves the whole of the part of greater value. So example, S is a partner in a partnership. He sells all his interest to B for the lump sum of 150,000 pesos. So upon the dissolution of the partnership, B received the share of S in its assets, consisting of 50,000 pesos. So some office equipments and a car. Subsequently, the car was covered by C, a creditor of the partnership. So, S is not liable to B because S does not warrant each of the various part of his interest in the partnership but only the legitimacy of his right as a partner taken as a whole. But if the value of the car exceeds 75,000 pesos, S will be liable because B is evicted from the part of a greater value. Kasi nga, 150,000 yung binili niya. So, if the value of the car exceeds 75,000 pesos, so that is a greater value. So, S is will now be a liable to the value. So, for Article 1632, according to Article 1632, should the vendor have profited by some of the fruits or received anything from the inheritance sold, he shall pay the vendee thereof, if the contrary has not been stipulated. So for the rule of a vendor, syempre binenta na niya ang rights niya, so from that right, nagkaroon na ng fruit. Since binenta niya ang rights na yon, so dapat kasama doon yung fruit, hence he will have to indemnify or reimburse the vendee. Kasi nga sa binenta niyang rights, included na yon as whole ang fruits. So pag may na-receive siya from that, right niya yan na he needs to pay the vendee because again, the fruit is included to the right na nabenta unless there's contrary stipulated. Now we're going to Article 1633. So, the vendor shall on his part reimburse the vendor for all that the latter may have paid for the debts of and charges of the estate and satisfy the credits he may have against the same unless there is an agreement to the contrary. So, for the rule naman of the vendee, so here the vendee received the right and to the relation to those rights may mga naging expenses sa vendor for those rights. Then, kailangan niya rin i-reimburse sa vendor doon unless there is an agreement to the contrary. And now, according to Article 1634, when a credit or other incorporeal right in litigation is sold, the debtor shall have a right to extinguish it by reimbursing the assignee for the price the latter paid therefor, the judicial cost accrued by him, and the interest on the price from the day on which the same was paid. A credit or an other incorporeal right shall be considered in litigation from the time the complaint concerning the same as is answered. The debtor may exercise his right within 30 days from the date the assignee demands payment from him. So for the Article 164, there is a legal redemption in sale of credit or other rights in litigation. So first we have this article is an instant or of legal redemption. The following are the requisites before the right of legal redemption can be exercised. So first we have there must be a sale or assignment of a credit. Second, we have the credit or another corporeal right must be in litigation. And third, there must be a pending litigation at the time of the assignment. The complaint by the assigner must have been filed and answered by the debtor before the sale of the credit. So, meaning of which is not a claim open to litigation, but one which is actually litigated. That is to say, disputed or contested, which happens only after the answer interposed in the suit. So, mayroong um, naganap na suit. So, number 5, we have the debtor must reimburse the assignee. So, first, the price paid by him. Second, the judicial cost incurred by him. And lastly, the interest on the price from the date of the payment. Now we have uh, um, the number 6, the reimbursement must be made by the debtor within 30 days from the date the assignee demands payment from him. So, in the absence of the demand of the assignee for payment from the debtor, the 30-day period will not begin to run. So, in relation to Article 1634, the purpose of grant of rights to the debtor. So the above provision gives an advantage to the debtor because he will pay less than the value of the credits assigned if he exercises his right to redeem the same. The object of the law of not allowing the redemption by the debtor is to avoid the purchase by a third person of credits in litigation merely for speculation. So now we're going to the last article of Chapter 8, Article 1635. So, from the provision of the preceding article shall be accepted the assignment or the sales made. First, to a co-heir or co-owner of the right assigned. Second, to a creator in payment of his credit. Third, to the possessor of a tenement or piece of land which is subject to the right in litigation assigned. So it must be emphasized that under both Article 1634 and 1635, the debtor cannot redeem if the credit of another incorporeal right is not in litigation when the same is sold. Under the Article 1635, we have three exemptions to debtor's right of legal redemption. First, we have sale to a co-heir or co-owner. Second, we have sale to a creditor. And lastly, we have sale to possessor or property in question. Now first, let's go to the sale to a co-heir or co-owner. This exemption is based on the desire to do away with co-ownership or pro-indivision. So moreover, if the right of redemption is granted to the debtor, it would not terminate litigation, which is the purpose of this article, because the co-owner or co-heir may still sue the debtor for the share that corresponds to the farmer in the credit. So, for example, D is indebted to B and C in the amount of 10,000 pesos. For failure to pay his debt, B sues D. If B transfers his credit to C during the pendency of litigation, D cannot redeem. So, let's go to sales to a creditor. So, for sale to a creditor, there is a lawful basis for the assignment, as the assignee cannot be considered as a vendee of a right in litigation and as a speculator. It really refers to a dation in payment, or what we call addition in pago. So, let's have an example. If D owes B sum of 50,000 pesos and B owes C of 8,000 pesos, now, if B assigns his credit, then the subject of litigation between D and B against D to C and D has against D to C, so D has also no right of legal redemption, because the law prohibits to do so, because what happens here is dishon and pago naman. What happened is dishon and pago ang nangyari, hindi naman speculative investment. So lastly, we have sales to possessor or property in question. So here, the reason for this exemption is that the assignee is moved by a desire to preserve the property and not to speculate at the expense of the debtor. So, example here is usually given where the vendee or the assignee of a property subject to a mortgage requires to mortgage credit of the assigner or the mortgage creditor against the vendor or the mortgage debtor. So here, it may also refer to a purchaser or a property under attachment who subsequently acquires the credit, giving a rise to the attachment. So for example, we have the example of if D owes B a 15,000 pesos, which is secured by a mortgage on the land owned by D. So if D sells the land to C and B assigns his credit in legal against D to C, so D is not entitled to redeem, because preservation of the property ang nangyayari, not the speculation speculative investment. So that is for this chapter 8. Thank you.